Much obliged, my lord.
My lord, on behalf of the petitioners, we have listened to the ruling. We have got no problem with the feasibility of it one way or the other. We leave it to our clients the decision on whether or not they will appeal the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never uttered. Be that as it may, I believe since we received some communications from the Deputy Registrar and there were certain other pending matters in the files that were under consideration, we shall await the directions of the court before, from the petitioner's point of view, we can say one or two things. I do not know whether, at least as my learned senior, Honorable Mwiche has anything to add.
My lords, your leadership, we appreciate that this honorable court of its own volition has granted leave to appeal. Speaking for myself, obviously the decision is that of the client. So I will be advising the client, but it is for the client to make the final decision. But in fairness to me as counsel and other counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this court. It is damaging to counsel, and that is an issue that definitely needs to be taken out of the record of this court by the Court of Appeal. It was a very unfair accusation. Thank you.
May it please the court, on behalf of the respondents, we thank you for the timely nature of the delivery of that ruling to allow this matter to proceed. We note that you have permitted the parties leave to appeal, and we support that. The respondents support a fair resolution of this dispute in accordance with the law, and therefore we would not oppose their right to appeal. Having said that, however, and in reference to my learned friend, Mr. Stephen Mundai, who has alluded to other petitions pending before court, it is the respondent's position that we should exhaust all matters today relating to the matter that has been called out by your clerk or your legal assistant. I apologize to the lady, so that we may exhaust that, after which the court will give directions on any other matter that may be before you or may be anticipated to come before you. Thank you.
That was coming up to
my Lord, my lady, on behalf of the National Assembly, I wish to express our gratitude for the very clear ruling that the court has delivered this afternoon. The ruling has dealt conclusively, not just with the matters that were contained in the application that was hurriedly filed and responded to yesterday afternoon, but indeed some of the other peripheral issues that the petitioners unfortunately took a lot of court time yesterday to deal with. My lords, my lady, the National Assembly has filed an application dated the 18th of October 2024. And I believe that application was referred to in the ruling a few moments ago. That application, subsequent to the ruling that you have just delivered, I submit is the next issue that the court should deal with. And just to put it on record, my lord, that we are ready to proceed with that application this afternoon. Members of the court will recall that last week on Tuesday, on the 15th of this month, at an hour not very different to this, when it suited the petitioners to have their application for conservatory orders heard, they insisted on it being heard. And we request that the urgency in this matter remaining and having been noted by the court, we proceed with the hearing of that application, which has been fully responded to, immediately after this. I'm most obliged.
My lords and your leadership, further to that, for Senate, I wish to state, my lords and your leadership, that unlike the petitioners, we are willing to argue the application in a record 30 minutes. Is it an application? Yes, the application dated 13th October 2024. We will only ask for 30 minutes to exhaust our application. We will dive straight into constitutional principles. We will not take much time. The respondents can have as much time as they want so that this matter can be concluded. My lords, Mr. Hilde has talked about the gallery of Paul Winter Senior Counsel. From that side, it was apparent that they were not just addressing the court. They were addressing other matters.
Do we need to engage? Do we need to engage in arguments on that? I was answering the question.
My lord, we are ready to proceed.
Stop exciting me.
I will withdraw the remark that the petitioners are addressing the public gallery today.
My lord, my lords, with your permission, my lady, yesterday we were barred for being part of these proceedings. We have seen communication that we are now legally here. We have stopped mourning. Could we be allowed officially by these files being called so that we are together? We still feel that we are excluded when we are before you. Our files, there is petition 5 E570, E550, E541, E572 that are supposed to be before you. That's, we complained to the CJ in the morning, and the CJ has directed we appear here and be part of this mosaic. Kindly, let us be part of it.
Your Lordship, equally, I rise as the advocate appearing in E509 and associate myself with the submissions made by my learned senior counsel, Paul Moite, and the ones made by my learned friend, Senior Hilde.
We need to be part of this discussion.
Your Lordship, to the best of our knowledge, in the matter E015, when we broke yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday indicated to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated, and now E565 consolidated, and we have been issued the notice that my friend Mr. Omari is referring to, that he also seized of 4 other matters: E570, E550, E541, and E572. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in respect to those particular files. I hope the court is in possession of this notice, so that the court may refer to the same. Subsequently to which, Your Lordship, will be seeking your guidance on how we deal with the applications filed therein, For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We would wish that subsequent to the court addressing and acknowledging that the other files before it, that I get directions on how to dispose of my application, for which, Your Lordship, the application was served